Swayam Prabha. Digital India. Educated India.
Let's begin. Law in any environment provides the basic framework of interaction between individuals, between individual and groups, between groups, within groups, and you can substitute the word groups for organizations and vice versa. And there you have the all pervasiveness of law. So, when you are trying to take a look at the basic framework of organizing for engineering, business and human resources management, a brief engagement with concerns of industrial law is inherent. Law is always contextual, whereas jurisprudence may have a global element, just as there are laws of physics and chemistry which have global applications. But the application of these principles are always contextual, and therefore, legalese is always contextual, and Indian industrial law would be very often very different, say, from the Chinese industrial law or the Japanese industrial law, though understandably there will be some common elements of a universal type. We are going to spend some time trying to understand the foundations of industrial law, the applications of industrial law and the significance it has for managerial action. In fact, industrial law has the Constitution of India as its pillar. Everything in India, when it comes to the legal dimension, originates from the Indian Constitution, which is the foundation of all legal framework of all levels, all civil society, of all that is called significant in human action, from the organized decision making systems, which is essential to any collective experience. The Indian industrial law is no exception. Therefore, it begins with the Constitution of India. But no constitution, not even the Indian Constitution, bulky as it may be, can possibly legislate for all situations. Therefore, enactments have to be passed by the duly constituted body, and the duly constituted body operates under the framework of the Indian Constitution, because there are items which are remitted to the central government for legislation, and there are items which are remitted to the state legislatures for legislation. In fact, one of the central acts of the Parliament and Assembly is legislation. In other words, keep the society civil, make sure the social contract under which civil society is preserved and operates. Then rules are framed by subordinate legislation. So, there is quite a sequence, because first you have the Constitution, then you have the enactments of the center and the state, then the rules framed by subordinate legislation, and the matter does not end there. There are specific items remitted to local bodies and authorities, and they frame the regulations. So, you have got regulations, rules, enactments, constitution, quite a hierarchy of a framework of civil society. All this affects industrial operations, and I would have almost said industrial action, but industrial action has strong connotations which are not intended in this presentation to be covered. And as if that was not enough, there are court records which are cited as precedents and very often become the basis for legal action and direction. Be that as it may, we now look into what could be called the extension of the foundation pillars into some of the important industrial laws. Of course, it is not possible in one sheet or at one place to list all the important industrial law, but without claiming even to provide a basic framework of industrial law in terms of itemization of what is significant, one has to highlight some of the key aspects, and the key aspects have to do with industrial disputes, where you have the Act of 1947, the Factories Act of 1948, the Contract Labour Law, which deals with Regulation and Abolition Act of 1970, and of course, there are certain acts which go back to pre-independence period still having validity, like the Indian Trade Unions Act, the Workmen's Compensation Act, the Employees Provident Fund and Miscellaneous Provisions of 1952, the Employees States Insurance Act of 1948. Here you have a brief listing of 7 acts, pre-independence, post-independence, and definitely not in a chronological order. But from names itself, you will be able to make out how this is fundamental to the very act of running the civil society, regulating management action, and enforcing a semblance of a framework of reference for production, services, even the manner in which they are to be handled in terms of precedences, and the story then rolls on to look at the workers versus the non-worker situation in industrial law. Given the demands of time, given the kind of situation in which we are placed, where we have to cover a whole universe in a limited period of time, it is my choice to familiarize you with the nature of industrial law in India under certain captions, one of which is workers versus non-workers. Labor can be broadly classified into unorganized and organized and organized sector. Unorganized sector is not regulated by any of the labor laws. Now, this is very important. Since such a large part of the Indian workforce is in the unorganized sector, and unorganized sector is an important contributor to national productivity, labor can be broadly classified into unorganized and organized sector. but there are no labor laws for the unorganized sector, and that is where a lot of action is deficient on the legal frame. Unorganized sector is identified by specified fixed operating conditions laid down by various labor laws, but unorganized sector does not have this benefit. Workmen derives certain rights and benefits from the various labor and industrial laws in India, and a non-workman is defined as employees carrying out managerial and administrative work, and their terms of employment is essentially derived from the contract drawn between them and the company. So, now we are in touch with the classical definition of the workman and the non-workman in the organized sector. The workmen in the organized sector are essentially the blue collared workers. The non-workmen are the managerial cadre, and they are governed by the contract. None of the labor laws apply to non-workmen. So, it is interesting. Labor laws do not apply to the unorganized sector, and labor laws do not apply to the non-workmen, and service conditions of such employees are governed by respective contracts, is what you heard me say. But gradually these boundaries are changing. There are elements which have been extended to cover the unorganized sector also, and that is gradually being pushed into many new areas. For example, the Minimal Wages Act has in many cases been extended to cover where a workplace need not be necessarily covered by the word industry, and leave rules have in certain states been extended to cover even the domestic servants. But it is not the legislation and the legal framework alone which operates a situation. What operates a situation is the likelihood of the detection of violation, the strength of the monitoring process, and the ability of the administering system to bring the recalcitrant individuals to heels and do something about it. It is there that one gets the feeling that many things may exist on paper. It is the operational dimension of that paper which is more significant, which has led to a quip which many people subscribe to. India is an over legislated, under administered situation. Perhaps the under administration is a fact of the over legislation which has taken place, and legislation after legislation has been enacted without paying attention to the delivery channels, the delivery vehicles, and the monitoring components of that law. People have not been prepared to administer that law. A system has not been put in place which will have sensors to track deviations. A mechanism for bringing to heels people who violate the law is not available. And if there are all these deficiencies, then it stands to reason that it will not be possible to have a practice of legal operations which creates confidence unless the delivery vehicles and channels of governance carry conviction to the legal process. While talking of the workers and the non-workers, therefore, one has to keep in mind the perspectives of the ground conditions before understanding the significance of industrial law. The workman also derives certain rights and benefits from various labor and industrial laws in India, just as the non-worker, I have said, goes back to a contractual relationship with the employer. Now, which then brings forth another classification, just as there are workers versus non-workers, there are non-workmen in the private sector. And the non-workmen in the private sector have their own issues. None of the labor laws apply to non-workmen, and service conditions of such employees are governed by respective contracts. So, the non-workmen in the private sector are even more vulnerable than non-workmen in public places. This is a dimension of industrial law which needs thought, and at the level of a principle, a question can well be asked: do we need legislation on this? Is the present situation good enough, or indeed are the aberrations too small to even merit a legislation? So far as the workman in the private sector is concerned, the employee only has recourse for damages, and in more cases than not, this does not come, because the contract is drawn up in a way which is highly biased in favor of the employer, and the employee is left to fend for himself, because at the initial level of the contract he has given or yielded such rights to the employer. This very often happens because of the need for employment, the pressures for employment, and people accept terms and conditions which ordinarily they would not have accepted if the choice of employment were wide. Courts in India are conservative in awarding damages, and punitive damages are rarely awarded. The drafting of employment contracts in Indian context is having considerable scope for improvement. Identifying the worker and employees not covered under the definition of workman respectively creates situation of exception, because they are with reference to the local laws of the state, and especially when employed by an all India organization, contracts almost always have a clause which says dispute in if any will be considered in the courts where the headquarters of the employer is. Now, if the employee is in Calcutta and legislation on a dispute, the adjudication on a dispute, the operation of a resolution in a dispute can be only in Bombay, where the employer's office is headquartered, that you can clearly see that the employee is in an unequal state to even get into the battle, let alone fight the battle. Therefore, local laws of the state where the headquarters is and where the employee is made to agree all adjudication will take place is loaded against the interest of the employee. The issue appointment letters which clearly define the employment terms and conditions again have a huge bias in favor of the employer. The employment contract should be put in place with clauses for wages, benefits, non-complete clauses, confidentiality clauses, terms, terminations, and what have you. In terms and conditions of employment should be clearly explained to the employees before execution and should be drafted without any ambiguity, and this is a beautiful sentence. There are any number of situations where the person signing the contract has even to certify that the sub clauses were explained to him to his satisfaction, especially those clauses with insurance and whatever else which have a risk element. And these are rushed through with signatures under the plea, oh, these are routine terms, do not worry, or no, everyone signs them without reading them, there is nothing to it, or worse still, do not worry, I will be still there. Now, these behavioral aberrations of legal situations in actual operations do a huge damage to the actual strengthening of the legal framework for operational safety of the employee. But as of now, this does not seem to worry anyone in particular, and no lobby group seems to have taken it up with any degree of significance. Industrial law and IR dynamics are yet another component to which I would like to draw your attention. Labor is a subject in the concurrent list of Indian Constitution, which operationally means that both the state and the center can legislate upon labor as a subject, but in case of a conflict between the legislation of the state and legislation of the center, the legislation of the center will prevail, which is why labor is a subject in the concurrent list of the Indian Constitution, is a statement which really shows that the union government will have its way should it choose to have its way. The labor law varies from state to state and therefore creates difficulties for IR managers. The IR managers are therefore not really in a position to be masters of all the different laws, and if the IR managers themselves are not in position to be a master of all the different laws of the different states to which they may be taken on transfer, what do you think will be the plight of the worker who has no legal background, no understanding, and obviously no recourse because of geographies for a solution? Dependence on contract labor is increasing at a phenomenal rate, and outsourcing is becoming the mode. As of now, there is no propensity either to curb it or to change it. Difference in wages of the regular employees and contract labor is a major issue of concern, as is one of the main causes for several disputes. The amendments in Contract Labor Regulations and Abolition Act of 1970 could really cover the dynamics of contract labor issues, and it is hoping that it will be wide enough to be real enough. Productivity and flexibility is not mentioned anywhere in Industrial Disputes Act, leading to a managerial dilemma. Now, if productivity is not even mentioned in any of the Disputes Act, what kind of surging forth can be seen as a part of the organized sector? In fact, even if you look at the public statements of significant public figures. Everything is talked about. Of course, popular words of secularism, reservation, equity, popular removal, socialism, justice are all to be found. But when you look for words like productivity and efficiency, one hardly comes across any pronouncement at that level. Now, if the public consciousness does not have it in itself to be stoked by this word, to expect that suddenly this concept becomes all permeable and all important in the functioning of the organization is a little bit of a tall expectation. And what is true of public pronouncements is true of the legal situation. There is a difference in opinions amongst major stakeholders regarding implementation of labor laws, and this does havoc to having justice of labor relations as the deliverables of labor laws. Now, it well might be argued that everything in law is subject to differences in opinion, but it is significant that differences of opinion should not detract from the actual merits of the administration of the law. Every judgment had its own opinion towards the applicability of labor laws. BHEL, Workers Association Haridwar versus Union of India, AIR 1985, SC 409, Gammon India Limited versus Union of India, AIR 1967, Supreme Court 691, etc., are merely indicators of what I am trying to illustrate. Which really brings us to a very important question: what is the effectiveness of industrial law? And in the backdrop of what has been elaborated, I do not think much needs to be said, which creates one of the major concerns of Indian industrial growth, because unless industrial law is fair, even, accessible, administered by enlightened people, the framework of industrial productivity will forever remain suboptimal. There are serious concerns of even the completeness of industrial law. It is about time concerted steps were taken, were initiated towards making the industrial laws complete and to the extent humanly possible exhaustive. The negligence of the organized sector is clearly a dark area of industrial law, but that is not the only dark sector. There are dark sectors elsewhere, not the least of which has to do with the kind of gaps which the manner of contracting throws up with the non-workman, the kind of variations which exist from one state to another, and above all the variances in interpretation and application of industrial law. The organized sector, it is true, gets much attention, while large organized sector unprotected by unions is little touched by law. But then the proposition that the organized sector, which has the prime attention of the legal operations, is a haven of peace, of productivity, is simply not true. The organized sector seems to be suffering from over legislation if anything else. And this over legislation has its own problems. In fact, the entire thrust of labor reforms is to bring to shape the over legislation in the organized sector. So, if one were to use a picturesque analogy, in one dimension of industrial law there is flooding, and obviously that needs to be cleaned. And in another aspect of industrial law, there is what could be termed as a parched lay of the land, so that it is utterly impossible to have any modicum of administration of justice, because there is no framework to provide justice. So, how does one ensure the effectiveness of industrial law, labor law and more? Apart from the issue of legal solution, there is the issue of social solution. And in India, the social dimension often tends to overtake the legal dimension. Another concern is the deterrent effect of legislative provisions. For example, many experts suggested changes in the ID Act to give flexibility to the employees to respond to market forces. How it happened is a story which has to be dealt with elsewhere. Role of the state in containing industrial conflict, strengthening unionism, collective bargaining and establishing industrial democracy has not been exactly something to write home about. The biases of the governance patterns of the state, sometimes suffering from sharp fluctuation, only widen the gap and leave the desire for correction more emphatic than ever. There are demands for reforming labor laws and withdrawal of state presence in IRS. The labor law reform has been in the air for quite some time, and several attempts have been made in vain. Indian IRS is a classic case of inaction. Major and minor committees have made recommendations, but nothing concrete in a sustained manner to outline the future directions of growth has happened. When Parliament is passive, then judiciary boldly took the initiative, but that leads to the allegation of judicial activism, which is another story, and I would like rather to move on to industrial law and FDI in India, because FDI is today more fashionable than perhaps any other thought. Whether it is more potent than any other intervention is a matter of strong debate, but the fact is, where the fiscal deficit of the country is so large and so under debated and even less actioned, to seek money through FDI would require an industrial law framework which has to be hugely biased in favor of the investors of a foreign origin, that one could almost be faced with a situation where the national interests themselves would need special provisions to be protected. In the last few weeks, the cap of industrial investment scenario has been hugely raised in certain sectors, but we need not get into that. What we have to focus is on the industrial law component, which inspires confidence in foreign direct investors or perhaps puts them off. We have been allowing foreign direct investment in almost all sectors in a very attractive way, and we have been progressively raising it. In certain cases, it has got up exponentially. The foreign investors, while making investments in India, has to make itself aware of the complex labor laws in India, and this must evoke confidence. This obviously will not happen if laws, not just labor laws, financial laws, taxation laws, and what laws have you, are amended with retrospective effect, as has happened in the past. Be that as it may, it is important to realize that legal framework is the framework to which all contending parties appeal, and all contending parties will have to recognize that making it rational is in their own interest. The Indian labour laws place considerable restrictions on freedom of an employee to reduce workforce. Now, this is something which no FDI person would be impressed with. If he cannot control the strings of employment, it is very difficult for him to be effective. In order to understand the nuances of employment, or even before coming to that, the nuances of employment are a subtle aspect. The right to close down a factory is a gross aspect. Even here there are deficiencies. What to talk of the nuances? But the labour and industrial laws would be pertinent to differentiate between law applicable to executive, management, white collar, and job and workman, blue collar job. So, you see the concern of distinction between the white collar and the blue collar is back. There is a need to think through on how you cover the workmen in the legislative frame, but how do you provide justiciable framework of equity, common sense, and of natural law justice to the non-workman. The emerging trends of labour laws in India are worth watching, because they are interesting, proactive, and have an operation beyond immediate relevance. The fact of the matter is, courts are interpreting laws more liberally, and they are providing to the employer more flexibility. Several amendments are on the anvil, which will give the freedom to the employers by not being required to make an employee permanent, even if the employee has completed 240 days. But this is still within the domain of contemplation, and there is a time frame, and there are processes which will have to be covered before it becomes law. It is another matter that somebody may debate even the good sense or the constructive dimension of this dimension of operation, but the fact remains that movement in the industrial law zone is slow and very often in directions which are not always clear to decipher. Labour laws in the special economic zone are supposed to be amended substantially with amendment in the Contract Labour Regulation and Abolition Act 1970, which will allow the employers to follow a hire and fire policy under certain conditions, but this again is in the domain of a possibility. With the whenever an election happens and whenever a parliament is dissolved, I think it is only fair and proper that everyone should know that all the pending legislations before that parliament get dissolved. And therefore, when the new parliament convenes, the processes have to be started de novo, and that itself requires a large time constant. That large time constant is difficult to control, difficult to manipulate, and at times even difficult to negotiate. The reason is the nature of parliamentary action has been distorted through many instruments. These instruments may be one of taking recourse to ordinance where a legislation was perfectly feasible, or perhaps using certain techniques of disruption on the floor of the House, which do not really add value to the discussion and indeed do nothing more than throw the proceedings out of gear. And of course, while these two extremes of a 180-degree situation will operate, subtle interpretation by statutory incumbents of positions in a way designed to further the act of governance makes one wonder how far the balance of power between the executive, the legislature and the judiciary is being kept alive by people who are active participants in the process, and how far this delicate balance of power amongst the three wings of governance, which was supposed to be one of the cornerstones of the Constitution, is today in danger of being tilted one way or another. The state and the IRS raises its own issues. Democratic political values informed the nature of institutions in IRS. This has gradually acquired strange shapes. There has been a lively debate on the relationship between the nature of the political regime and the economic growth and inequality, but the debate remains unresolved, and industrial law as it exists today may have been a potent instrument of pushing the debate in one direction or another, but the ground conditions do not seem to be leading to it. Civilian regimes are compared to military regimes and appear to do better in terms of improving the basic quality of life of the masses of the citizens, but the debate stands basically between comparisons not so much of military regimes, but of what is happening in India and what is happening in a very different kind of a governance system in China. And it is obvious that China as a governance process is showing dramatic results. There is no right mix of industrialization strategies and IR policies set. They are always contextual, they are always time bound, and they always need a lot of wisdom to think through. The role of IRS in India is extensive. The state's presence is primarily felt through legislation. The legal arm is long and covers almost every aspect of IR. The inevitable query then relates to its effectiveness. For the law to be effective, a sound administrative machinery and proper societal attitudes are required, and this could not be emphasized enough. For the law to be effective, a sound administrative machinery and proper social attitudes are required. It is common knowledge that the administrative machinery for implementation is inadequate, often toothless, and even corrupt. Which brings us to the issue of tripartism and IRS. Tripartite forums were revived since mid-80s, but the revival was not entirely successful. Tripartism, in order to be successful, should have relatively equal degree of influence by the three actors, representative of the actors' respect for the results of the tripartite process. Consensus generated at the grassroots level is more purposeful than at the tripartite process. And finally, a little bit of a comparative perspective on legislative situation in India, industrial law in India may help to put the debate in perspective. We may see our own strengths and weaknesses more clearly. Therefore, laws and values, a case of US is cited. What are the values in United States? Individualism, a right of individuals superior to other rights, property rights, a derivative of individual rights, individual free to order economic transactions so long no laws are broken, there is a freedom of contract, corporations are legal individuals in law, purchase and sales of labor is an exchange transaction, unions attempt to be collective. Now, this continues in terms of unequal status of employees and unions, conflicts between individual property rights and collective rights persist and usually resolve in favor of individual rights. The reserved rights theory of management also exists, and one can see that even in United States there are gray areas, there are areas of strengths. So, there is nothing to put ash on our head about our own deficiencies. On the other hand, in certain areas our legal system has shown considerable independence, an understanding of the fundamental drives, and has pushed in the right direction. But there is one thing which needs to be observed about, say, typically the US system, the clarity of the direction in which it moves the society. In Indian case, while we have a lot of sloganeering, the legislative framework is not always clear on the direction in which it could move the society, and this is something which can easily be responded to. But to conclude, therefore, there is a set reading list here which is essential to wrap up any discussion on the industrial law framework, because no matter how well it is treated, there are bound to be gaps. As usual, I would like to conclude with a recommendation that please follow up your preparedness of reading and understanding, which these presentations are supposed to inculcate in you, amongst other things, with necessary reading. This is not the end of the discussion, this is not the end of the course, this may well be just the marking, a beginning of your real understanding of the issues which drive this country, which goes towards making of managerial effectiveness, and how you wish to find your own space therein. Thank you so much.